A guide on what not to say in a custody trial in Tahlequah. Custody trials are often emotional, stressful, and deeply personal. Parents naturally want the judge to understand their frustrations, concerns, and disagreements with the other parent. However, one of the biggest mistakes parents make during a custody trial is saying things that damage their credibility or make it appear they are more focused on attacking the other parent than on protecting their child's best interests. Understanding what not to say during a custody trial can be just as important as understanding what evidence to present. Avoid speaking badly about the other parent. One of the most common mistakes parents make is turning the trial into an attack on the other parent. While legitimate concerns regarding abuse, neglect, substance abuse, or safety should absolutely be presented to the court, constant criticism and personal attacks often backfire. Judges hear custody disputes every day and understand that divorcing parents frequently have strong negative feelings toward one another. A parent who spends most of their testimony insulting the other parent may appear bitter, vindictive, or unwilling to support the child's relationship with the other parent. Instead of making broad accusations, focus on specific facts, specific incidents, and evidence that directly affects the child's well-being. Do not tell the court the child hates the other parent. Parents should be extremely cautious about statements such as, "My child doesn't want to see their father," or "My child hates being around her mother." Judges often view these statements with skepticism, especially when they come from a parent involved in a contentious custody dispute. Courts understand that children can be influenced by adult conflict and that emotions often fluctuate during family litigation. If a child's preferences are relevant, they should be presented through appropriate legal channels and supported by evidence rather than exaggerated claims. A parent who appears to be encouraging alienation from the other parent may significantly harm their own custody position. Avoid saying you will never cooperate. Statements such as, "I will never work with the other parent," or "I refuse to communicate with them," can be extremely damaging. Oklahoma courts generally favor parents who demonstrate a willingness to cooperate and facilitate a healthy relationship between the child and the other parent whenever it is safe to do so. Even in high-conflict situations, judges want to see evidence that both parents are willing to place the child's needs above their personal disagreements. A refusal to communicate or cooperate may cause the court to question whether the parent can effectively support the child's relationship with the other parent. Do not exaggerate the facts. Another common mistake is exaggerating allegations or making statements that cannot be supported by evidence. For example, claiming that the other parent never sees the child when visitation records show otherwise can quickly damage credibility. Likewise, making accusations involving abuse, neglect, drug use, or criminal conduct without supporting evidence may cause the court to question the truthfulness of other testimony. Judges often place tremendous importance on credibility. Once credibility is damaged, it can be difficult to regain. Avoid discussing unrelated personal grievances. Custody trials are not designed to resolve every complaint that arose during the relationship. Judges are generally not interested in who was the better spouse, old relationship arguments, dating disputes, personality conflicts, or minor annoyances that do not affect the child. The court's focus remains on the child. Testimony that drifts into unrelated personal grievances often distracts from the issues that truly matter. Parents should constantly ask themselves whether the information directly affects the child's best interests before raising it in court. Never lie or guess. If you do not know the answer to a question, say so. Many parents feel pressure to answer every question during trial. However, guessing, speculating, or attempting to provide information that is not actually known can create serious problems during cross-examination. Judges generally appreciate honest answers such as, "I don't know," "I don't remember," and "I would need to review the records." Attempting to fill memory gaps with assumptions often creates inconsistencies that damage credibility. Do not interrupt the judge or witnesses. Courtroom behavior matters. Parents should avoid arguing with the judge, interrupting opposing counsel, talking over witnesses, rolling their eyes, making faces, or displaying visible hostility in the courtroom. The judge observes not only what each parent says, but also how each parent behaves. Respectful and professional conduct often helps demonstrate maturity and self-control. Parents who lose their temper during trial may unintentionally reinforce concerns regarding their judgment or ability to manage conflict. Avoid saying the child is better off without the other parent. Unless there are serious safety concerns supported by evidence, statements suggesting that a child should have no relationship with the other parent are often viewed unfavorably by the court. Tahlequah courts generally believe children benefit from maintaining meaningful relationships with both parents whenever it can be done safely. A parent who appears determined to eliminate the other parent's role entirely may create concerns about their willingness to foster a healthy parent-child relationship. The court is usually looking for solutions that support the child rather than punish the other parent. Stay focused on the child. The strongest custody testimony is usually testimony that remains focused on the child's needs rather than the parent's frustrations. Judges want to hear about the child's education, medical needs, emotional development, daily routines, stability, safety, and future plans for the child's well-being. Parents who consistently bring the discussion back to the child's best interests often present a stronger case than those who focus primarily on their disputes with the other parent. Tahlequah child custody attorneys. Many custody cases are won or lost based upon preparation, credibility, and courtroom presentation. Even a parent with strong facts can damage their case by making emotional statements, exaggerating allegations, or appearing unwilling to co-parent. Because custody decisions can affect your relationship with your child for many years to come, proper preparation before trial is one of the most important investments a parent can make. Our team at Tahlequah Lawyers is here to guide you. Call 539-867-2321 today for a free and confidential consultation with one of our child custody attorneys.